Good morning, everyone. I'm Olivia Rios, Director of Operations and Programs at the LA Latino Chamber, and we'd like to welcome you to today's webinar. Today's topic is 2025 California labor laws. We will learn what those new laws are, and we'll share the impact it creates on California businesses. Our speaker this morning is Candace Keller, Human Resources Consultant at BBSI, a PDO company who locally supports and provides solutions for payroll, HR, workers' compensation, and health benefits. Having a business in California has its challenges. As the largest state in the U.S., it has a GDP that rivals many countries. Today, we'll have Candace, who will share what those new laws are and its effects on businesses, as well as addressing the minimum wage, which has increased and has a host of implications on its own. And lastly, tune into the latest. So with so many laws, it's really a daunting task to remember what those are. And that's why it's important for chambers like ours to help educate businesses, employers with the latest mandates. Today, Candace will go over the risk of hiring, new wage compliances, and we'll share best practices to minimize risk and prevent costly errors. Please write your questions on the chat. We will answer them at the end of each topic. So Candace, welcome. Thank you for taking your time on a Tuesday morning to share these important laws that really affect everyone here on this webinar.
Yes, good morning, everybody. How is everybody doing this morning? Hopefully everyone's doing well and staying well. Excited for this presentation. So let me go ahead and share my screen so we can begin the presentation. So is everybody able to see? Are we good to go?
Yes, good to go.
So we are going to go into the new California employment laws for 2025. I do want to let you guys know before I start that I will be stopping in between 5 or 6 slides or so to take any questions if you guys have any. So please put them in the chat and we will get to those questions every 4 or 5 slides. So I do want to do a disclaimer. The contents we are providing are presented as a general information, and it's not legal advice. So obviously anything that you guys have from a legal standpoint that you guys may have questions about that I'm presenting, definitely if you guys have employment lawyers to go ahead and speak to them. BBSI undertakes no obligation to update the information in this presentation, and no representations are made that the content is error-free, but everything we are presenting today was presented and given to us through other legal channels. We go to many different legal updates from lawyer offices. So today's agenda, we are going to go over minimum wage updates, overview of new major California laws, and we are going to discuss any vetoed and stalled bills. The vetoed bills, obviously that means that they were denied, but there are some bills that are in the pipeline that are stalled at this moment. We do not have dates and times on when those will be either vetoed or approved, but they are being stalled in the system. So we are going to go ahead with the minimum wage update that hopefully everybody's already aware of now that we're into February, but if not, we're going to go over them. So the state minimum wage, this goes for non-exempt employees, has gone up to $16.50 an hour for all employers. Back a few years ago, they used to say like, oh, $16.50 if you're under 25 and $17 if you're over 25. That is no longer an issue here. The Department of Finance has announced that it's a statewide minimum wage for all employers to increase to $16.50 as of January 1st. Proposition 32, which did not pass, would have increased it to $17 this year and $18 next year, but that did not pass. So that is, I know, something that probably small businesses were kind of nervous about, but it didn't pass. So right now, the minimum wage is at least $16.50. Once the minimum wage reaches $15 an hour for all businesses, wages could then be increased each year up to 3.5%, rounded to the nearest 10 for inflation. It has been increasing over the last 3 years due to this clause. It was a clause that was in the new law. But there are industry-specific and local minimum wages that are higher that still are in control. So obviously, fast food workers, we know that went into effect at $20 an hour. And then there are some hotel workers, it varies by region, that they also have a different minimum wage. So I hope it's kind of small. I don't know if you guys can see it, but local minimum wage ordinances. So as long as you are abiding by California's minimum wage, you can go above that. So all of these cities have different minimum wages that are above the 1650. So if you are in any of these cities and you operate business in these cities, you guys can, contact me an email if you guys want to know what your minimum wage is. But all of these cities, I mean, Pasadena, San Diego, San Francisco, Daly City, I know that that's up north. Up north has very high minimum wages because of their cost of living. Los Angeles County and Los Angeles City both have different minimum wages than the California minimum wage. So Malibu. So just if you guys have questions and you are operating a business in these cities, go ahead and reach out to me and we can discuss what you have to pay your workers in your city. So these are some of the rates. Alameda is 17, Berkeley is 1867, Cupertino is 1775, Los Angeles is 1728, San Francisco 1867, Sunnyvale 1855, West Hollywood as of 1/1 is 1965. So again, if you are operating in some of these cities, let me know. The 1965 for West Hollywood actually went into effect 1/1/25. A lot of these went into effect July 1st of 2024. And usually in California, we get updates in January and we get updates in July. So there could be things coming down the pipeline that get implemented as of July of 2025. We will obviously contact our, with BBSI, we contact our clients. We let them know if it affects them. We keep them up to date. So just keep that in mind for your guys' businesses to keep an eye open in January and July, because that is when California tends to implement new laws and regulations. When we go into minimum exempt salary, that's different. So don't forget that minimum wage does affect salary exempt employees. So your employees who are salaried and exempt, they went to $68,640 this year. So it's double minimum wage, which is $33 times 2080. That's how we calculate the annual salary for someone who is salaried. It has to be at least double minimum wage, which now it's $33. And you times it by 2080, which is the amount of hours that an employee works a year. So in this situation, or now in California, it's $68,640. City ordinance and county ordinance do not affect exempt salaries. So for exempt, you still have to be at least $33 an hour, regardless what your city's minimum wage is. So just, I want to keep that clear that if you are in LA City or Sunnyvale or San Francisco, they still have to be at least $68,640. It doesn't have to be double the minimum wage of that city. It only affects minimum wage when it comes to the changes in the hourly pay. So just, that's a big thing. A lot of people, and I've dealt with a lot of clients where when they come in, they think that if they're paying them $58,000 that everything's fine because they're not technically paying them an hourly wage. No, there's still a minimum wage for salaried employees. So keep that in mind. If you have salaried employees, they do need to be at least $68,640, which equals $33 an hour.
Thanks for breaking down the math, because sometimes people are wondering, is that a specific formula? But it is.
It is. I do 2080 with everything. So if I see somebody's salary, I always divide it by, but you also times it by 2080. And that, like, if they're like, well, I want to pay them $26 an hour. Okay, well, let's check that times 2080. Unfortunately, that still doesn't meet the threshold. So yes, 2080 is the number to go by when you are calculating somebody's annual salary. So we're going to go ahead and dip into the employment laws for 2025 that are not minimum wage. So how did we get here? California legislator. So every year in California, the governor signs new bills that usually become law January 1st of the new year. According to the Office of Governor, approximately 1,000 bills reach the governor's office. Over 2,100, almost 2,200 are introduced. 817 bills are signed in or were signed in, and 183 bills were vetoed. In 2024, if none of you guys have had your handbook updated since 2024, you absolutely should get your handbook updated. 2024, there were thousands of laws. I want to say it was almost 2,000 that he signed into law in 2024. 2024 was a very big law year for California. So if you guys have not had your handbook done, since before 2024, it is absolutely imperative that you guys get that done because 2024 had a lot of new laws signed in, and I am almost 1,000% sure your handbook will not be compliant if you did not update it in 2024. 2025 is minimal. It's a lot, but it's minimal compared to last year. So just please keep that in mind to get your handbook updated if your handbook has not been updated since 2024 or since 2023, not for 2024. So one of the biggest things is PAGA reform. PAGA obviously is kind of like a bad word in the world of business and in the world of HR. It is a scary thing. It can cost companies a lot of money, but there is a little break this year for businesses. So when it comes to PAGA reform, the legislation came after months-long negotiation between business community and labor leaders and as part of a larger negotiation involving various propositions on the ballot. That multiple changes have been made that impact how we prevent and respond to PAGA claims. There's was a penalty modification. There's restricting scope of claims to those that the plaintiff has suffered, implementing standards in litigation, and cure provisions. So when I say that, PAGA now includes the possibility for a significant reduction in penalties if employers have taken all reasonable steps to be compliant. Reasonable steps can include conducting payroll audits. So when a lot of these PAGA claims, wage and hour. And so if you are acting on those audits based on the results, and you can show, if you get a PAGA claim and you can show proof that you have done an audit and you corrected any of those issues, such as unpaid overtime, meal and rest break violations, or expense reimbursements, if the employer finds through their audit that these actions actually did take place and they were not compliant, you do get the chance to kind of make it right by showing that you have conducted these audits and you have tried to make things right. Also, having written policies in place related to wage and hour practices and ensuring that those policies are distributed and enforced. Obviously, I will always, till my career ends in HR, if you don't document it, it didn't exist. It doesn't matter if you can say that you had 7,000 conversations with your employees. If you do not have proof, like sign-in sheets, every time I make sure my clients understand, anytime you do any sort of new introduction to anything that's happening, whether it's the way that they clock in and out or safety situations, everything should have a sign-in sheet. Especially, I work with a lot of warehouse and manufacturing. It's kind of hard when you have 80 to 100 employees, but you can get a sign-in sheet, and the employees, at the top, you just state what the meeting was about, the main points, whether it's sexual harassment training, whether it's, lifting and safety standards inside of the warehouse. You should always do a sign-in sheet, because when these audits come in, or if you were to, God forbid, get a PAGA claim, you can show proof that, no, we go over this monthly, we talk about these things, we have these policies in place, here's the signature of the employees that signed stating that they received their handbook, stating that they've received this training. It does actually go a long way. Being aware of industry-specific applicable wage orders. So I hope that everybody has their wage orders posted for their employees, which they kind of keep it, you should keep it by your wage labor posters, but making sure that you have the company policies that are in line with those wage orders is important. If anybody has questions about wage orders and what wage orders they should be in, you could definitely reach out. But your HR person should have that information, and it should be posted for your employees to have. Obviously, like I mentioned earlier, ensuring supervisors and managers are trained on applicable labor code requirements and basic wage and hour rules. That is extremely important. You guys have no idea how many owners that may know the law, and I deal with them and they do great, but their management team does not. Therefore, those are the people that are managing the employees, and they are the people that are unfortunately violating wage and hour laws, causing the trickle up effect, where it's the owner that's going to have to deal with the backlash of that, because they're the ones that are going to be signing the check for the lawsuit. So it's really important to make sure that your management and your supervisory team, your leads, understand about, the law, the lunch rules, the break rules, the overtime rules. We want to make sure that they are trained just on the basics, and that's extremely detrimental to a company when that is not. We talked about the payroll audits, the policies, industry specific, and then taking corrective actions with supervisors and personnel. who may be involved with wage and hour violations. For example, if an employer has a supervisor who's lenient on the timing of when they're to take meal and rest break periods, we want to make sure that you address it. And unfortunately, you probably should do write-ups, or I call records of conversations, which I guess could be a write-up, but it's not. It's just, hey, we had this conversation. You understand this conversation. I'm just documenting that we had this conversation on paper. Being able to produce those documents could go a long way as well. So it looks like the way that they have decided to change PAGA and be able to give the employers the opportunity to fix the problems that as they've arose, right? And so it gives you the opportunity to document, to conduct audits, to make sure that you guys are staying on top of stuff, so that when you show the proof of this, it says that you'll have the ability to reduce penalties up to 85%. So by being able to document, to show proof that you're doing what's necessary to eradicate and mitigate these issues that you're having in your business from a wage and hour standpoint, you can end up, reducing penalties up to 85%, as long as you take these reasonable steps to ensure wage and hour compliance. And like I said, those were the reasonable steps that I explained earlier: taking corrective actions, and training and documents, policies, procedures like that. Things like that will definitely help. So, Employer Communications, SB 399. This significant new law concerns employer speech. So it's ending so-called captive audience meetings. And I'll be honest, in California, I guarantee you that 99% of you are not, this will not even apply to you, because I think we've been conditioned that this is something you just don't do, but it is happening. So so-called captive audience meetings during work hours. Specifically, the law prohibits an employer from subjecting or threatening to subject an employee to discrimination, retaliation, or any adverse action because the employee declines to attend an employer-sponsored meeting when it has to do with the employer's opinion on religious or political matters. So surprisingly, based on this law, it is happening in California, where businesses are forcing their employees to go and attend meetings in their business for their own personal political and religious matters. So the new law defines religious matters as relating to religious affiliation and practice, and the decision to join or support any religious organization or association. And political, same thing. It's defined as matters relating to elections for political office, political parties, legislation, regulation, and the decision to join or support any political party or political or labor organization. So basically, I guess, how they say you got to keep things separate. Religious and political matters need to be kept outside of the business, and you cannot force your employee to attend meetings that you feel are important to you regarding religious or political matters. The law provides that the employee who is working at the time of the meeting and elects not to attend must continue to be paid. So you can have these meetings, but they're not required for employees to attend. So I do want to make that clear. My advice would be never to have these meetings, because it's just something I would never advise a client to do. But if that's your choice, your business, if you choose to, it cannot be mandatory, and an employee who does not choose to participate cannot be retaliated against. So I just want to make sure that is clear. Additionally, the law does not restrict employers from engaging in communications or training that are mandated by law or necessary for job performance. So for some reason, there's a lot of craziness going on with a lot of different laws being passed right now and executive orders. If the training is mandated by law or necessary for job performance, then that's a different situation. And if you guys need assistance because there's certain meetings that you need to have and you're not understanding, definitely reach out to your HR person, or if you're a client of mine, reach out to me. And then we can let you know if that's something that, yes, you can mandate for an employee to attend, or no, unfortunately, that is a political or religious opinion and your employees should not be forced to attend. So it's going to deter companies from communicating at all about political matters, including informing workers about impacts of legislation, hosting fundraisers, and supporting local candidates. Again, you can do it, but it can't be mandatory. They also did an enactment in 10 other states. There's a few things that are still going through legislation, but as of now, we just want to make sure that you understand that anything dealing with your own political or religious affiliation or opinions, those meetings cannot be mandatory. And if the any employee chooses not to attend, they still have to be paid. for the time of the meeting, and even if they don't attend.
A question for Maria.
Sure.
99% of our staff are field staff. We provide a mobile phone. Can email conversations be used as a record of conversation, warning, etc.?
Yes, absolutely.
Okay,
As long as the employee gets it and you get it, that is considered documentation. Yes.
Okay.
We do it all the time in HR. It's a, we call it, we just do a follow-up. So after a phone call, I follow up with my clients like, hey, just, this is what I need from you. This is what you want from me. This is, so we have a mutual understanding. Absolutely. Email is considered documentation. I would refrain from text message, but it would be considered documentation, but I'd prefer email. Absolutely.
Okay, so if a meeting or training is job related, you can require employees to attend.
Correct. So if there's any safety training, legal training, handbook training, sexual harassment training, anything like that, absolutely. It is mandatory for employees to attend. Yes. So again, but if it has to do with, well, I'm Republican or I'm Democrat and you need to come to my meeting and we're going to support this governor and we're going to support this president, we're going to support this. No, those can't be mandatory because that's your choice and your opinion and you can't force it. But if it has anything to do with company policies, procedures, law mandates, safety training, IIPP training, anything like that is absolutely mandatory for employees to attend. Yes.
Alrighty, another question. If a new owner calls a staff member the office manager, is that considered exempt employee? Even if the employer tells them they only have 10 PDOs, paid days off a year.
So being salaried or exempt has nothing to do with the title. It has to do with job duties. So I can be the president of the company, but my job duties is making copies all day. That doesn't qualify me to be an exempt or salaried employee. I can provide, if anybody need, I can provide it to Olivia. There is a checklist, and there's actually 4 different exemptions. There's professional, there's administrative, there is like a salesperson, and then one's like for like doctors and stuff like that. So you have to meet these thresholds, and aside from just salary is one of them. The other one is there's a whole bunch of kind of like duties that you do. You also kind of have to be in charge of staff in order to be considered exempt. You have to be able to make decisions without having to ask somebody. So if you are able to pay bills, if you are able to change policies and do stuff like that without having to ask your supervisor and you are given the autonomy to be able to do that, that's another kind of a duty. But just because you have a manager title does not entitle you to be exempt, and paid days off have nothing to do with exempt. You can have 900 days off a year. I mean, there's not 900 days, but if you had, it wouldn't qualify you as being exempt. It's the duties that you perform that qualify you for being exempt. And I'm going to write that down. I will send them to Olivia, the all 4 different checklists that are available for companies to be able to determine if a position qualifies for exempt.
Okay. Then there's another question. What are your thoughts on 50% of your staff are on 1099s and 50% are on W-2? What strategy is recommended?
1099 is like salaried. There is a ABC checklist to even be able to, now that the laws have changed with 1099, which are considered contractors, there's a checklist that you have to go through to even be able to say that your person is a 1099. And a lot of companies get confused because they think if they put somebody 1099, like it's easier, I don't have to deal with the taxes. That's not necessarily true. It actually can come back and bite you and be really expensive. And I'm going to go, there's a little bit of independent contractor information in here. I believe the new laws came out in the last few years. They've been constantly changing for independent contractors, because you can't, if you have 3 warehouse people and 2 of the warehouse people are independent contractors and one's not, you're in trouble, because the independent contractors do the exact same job as the employee. Therefore, it's almost like you were trying to not give certain benefits to your independent contractors. That's why these changes came into place, is because a lot of employers were using 1099 employees in order to be exempt from having to deal with the tax aspect, having to provide benefits, having to do certain things that are required by law for actual employees that are hired into your company. Therefore, my advice would be, I think that, and I could be completely off and you've already done all this, but my advice was you need to look at the ABC test and you need to determine if all of those 50% of your staff actually qualify as a 1099 employee, because if they don't, need to be rolled over instantly into your business, or you could end up looking at a lot of penalties and some lawsuits, because your 1099 employees have to be able to provide a trade that your employees that you currently have don't already provide. So if you are a construction business and all of your people focus on carpeting, and that's what your employees do, but your 1099 employees do roofing, but none of your employees do roofing, you can 1099 someone that comes to your certain jobs and they do the roofing for you. But if all these other people are doing, carpets, and you hire some 1099 employee to do carpets, it's going to be, well, why would you do that? You already have employees that do carpets. So it kind of has to be a specialty trade in order to qualify for a 1099 employee.
Someone's asking a question. Are there certain industries or positions that are exempt from minimum salary?
There are certain jobs, and that's sales too. So inside sales, commissioned employees, people that are doing sales for your company, some of them, depending on, and like I said, there's independent sales, and it really, you have to literally do a job analysis to be able to determine if that employee qualifies to be more as somebody who works off of commission and isn't required to be paid the minimum salary threshold. But that would be something that we would have to look at the job analysis, exactly what they do for your company, what kind of company and business you have. It is literally a company by company basis, because it really determines on what that job duties are and what your job description says. Job descriptions are extremely important. A lot of people think it's not. It is, from the beginning of hiring through termination and in between. Having a job description, it makes a world of difference. It's important for holding employees accountable. It's important for job analysis like this to determine whether somebody is eligible for 1099, whether they're eligible for just commission-based pay, whether they're they have to be paid salaried, a minimum salary. There are a lot of nuances with sales, and I would say sales is mainly the only one. And I think there's some with hospital workers, like I said. It really depends on what your industry is and what the job description says. So if you don't have an HR person, it's really important that you look into talking to somebody, because if you have a lot of salespeople, that will change the dynamic of their pay. Absolutely. It can be that they are not subject to that.
Okay. All right. I think that's it for now.
Okay, perfect. So whistleblowing posting requirement. The new California whistleblower law protects employees who report illegal or unethical activity in their workplace. These laws prohibit employers from retaliating against employees who are whistleblowers. Really, there's a law against all retaliation in the United States. It's a federal law. So I am really big on just don't retaliate at all. But the law requires the California Labor Commissioner to develop a model list of employees' rights and responsibilities under California's existing whistleblower laws. That has not come out yet. Once that list is developed, the Labor Commissioner will publish it on its website, and employers will be required to display that list. So for BBSI, we will be as soon as this gets released, we will be giving our businesses the documentation that they'll need to post. I think it's really important, if you are not a client of BBSI, to make sure you stay on top of that, so that you can post this as soon as it gets out. Once it's published, you guys have to post the list in an area employees frequent. I usually say break and lunchrooms. It's the same place that you would put your labor law posters. And the lettering has to be larger than 0.14. So, and it also has to include the telephone number for the whistleblower hotline, but all of that will be on that form. Once it gets released, I'll assume, I'm hoping the government's pretty smart with that, and they'll put that on there, but we don't have to search for it. So please monitor when the Labor Commissioner issues this poster, and ensure that it's posted in all required areas. And so again, once that comes out, we'll make sure and get that out to any BBSI employers. If you guys are on this call, you guys will get it. And Olivia, you will obviously have it. Again, retaliation, huge, expensive, don't do it. Hopefully you don't ever have to deal with anything like that, but it's California, they are sue happy. We kind of know as business owners how that goes. So victims of violence, AB 2499. So this new law strengthens the protection of victims of crimes by identifying it as a protected category under FEHA and allowing for claims under FEHA to be brought for adverse employment actions against the victim. So domestic violence, sexual assault, stalking, acts that cause bodily injury or death, acts in which a firearm or other dangerous weapon is used or brandished, and acts in which an individual uses or threatens to use force against another individual to physically cause them harm or death. Reasonable accommodations for victims of domestic violence, sexual assault, and stalking. And employers with 25 or more employees cannot discriminate against an employee who was a victim of those specified crimes or whose immediate family member is deceased. So the only change in this is now victims of violence are a protected class. So just like the other protected classes in California, now being a victim to these sorts of violences are now considered a protected class. It includes a new posting notice. So if you guys have your new labor law postings, they should be on there. If not, you can go on the website and you guys can pull it off of there. Anything, if you guys don't want to purchase a poster, some companies don't want to purchase a poster, you guys can go on the Department of Civil Rights, you guys can go on the website, you guys can print out all of the required postings. Granted, the posters are kind of compact, so it makes it easier, but the postings are for free on the website, so you guys can go on there and pull those. It also expands the definition of a family member, just like they did with FMLA, from an immediate family member to an expansive definition of family member under CFRA, including a designated person. So now the law states that you can designate a person it's your dog, it's your friend up the street. You can designate that person as a family member now, and they will be considered a family member under the law. It entitles employees working for an employer with 25 or more employees who have a family member, designated family member, who is a victim of a qualifying act of violence to certain protections, including taking time off work. The time is unpaid, but employees can use sick time if they choose their own sick time that they've accrued. They can use it for this time off if they need to take time off of work to assist a family member to obtain relief, such as a temporary restraining order, or to take time off to assist a family member to obtain victim services, such as medical attention, psychological counsel, or safety planning. So those are some of the changes that have happened. Again, the time off is unpaid. It should be in your handbook. Your handbook should be updated with this, and so that employees know, should they need these protections, it is available for them.
Before we go into the next section,
sure.
There's a couple questions. One moment, please. So that. Can you share the website for the required posting?
Absolutely. I will make sure I'll put that in there. And not just that required posting, it's all required postings for California. And they also have them in different languages, which is super beneficial.
And that's the one to download all the free posters, correct?
Yes. It is the, I think they call it now they've changed the name of it. It's a California Civil Rights Department. So it's called CRD. Yeah, California Rights Department. And so I'll send that website and I'll send the exact link to the posting so you don't have to go search all over the website for it.
Okay, perfect. And then another question regarding AB 2499. What type of notice is required? Often the ER is unaware of these acts.
So they just need to come to you and they need to let you know. If you don't know, you can't do nothing about it, right? So the employee does need to tell you, and they do need to let you know, hey, this is happening to me, my cousin. And usually they go to HR people. They're going to go to people where they feel comfortable, unfortunately, especially with something so sensitive. That when they come to you and they tell you, hey, I need to take time off because, I'm dealing with some domestic issues at home. I need to do this because my cousin has been a victim of so-and-so. Your instant reaction will be to, yes, you are entitled to these protections. You can take time off. Now, if you don't have 25 or more employees, it's not required by law, but I think that we all are human and we all go through things. And I think a lot of employers are still going to extend the time off. It's just not a requirement of law under 25 employees. But it's really important that you keep an open door policy. Again, a lot of employees probably are not going to come to you. It's a very rare instance that I, in my 14 years of HR, have ever dealt with an employee that's come to me because they need help or time off because of these sort of situations. It is a rare situation. It's not that these things aren't happening. It's just a lot of people don't come to their place of business to discuss those things. But this is just a protection should they come to you. So if you don't know about it, you can't do nothing about something you don't know about. So all you can do is provide this posting, which it should be on your labor law postings. If not, you'll put it up once you get it from the website. And so that the employees at least can read it when they're on their lunch break, they see it, they know it exists. That's really all you can do. So if they don't come to you, then there's nothing you can do.
Alrighty. What about someone's asking, Jeffrey is asking, what about the new active shooter regulations?
So that's actually for the workplace violence law that came into play, I believe, July of 2024. BBSI, we provide all the training for that. We do your workplace violence prevention plan. Definitely look to your HR person. We are not going to go over that in this slide because that is a law that went out last year and that would have been discussed last year. But I can tell you that yes, it is required by law that you provide training to your employees for workplace violence. And I believe, don't quote, I'm not the risk manager, but I believe there's 4 different acts of violence. And our risk managers in BBSI, we actually go out to our clients, and we have over about 500 clients in this branch, and we actually provide training to our clients should they want it. And they train the employees on the 4 different acts of violence, how they're supposed to react in those acts of violence, what their responsibility is for themselves. Then we also provide the workplace violence prevention program. So you need to have an actual program like you do for an IIPP, or now that they've not made COVID prevention plan. I don't know if you guys know that. This just got signed in February from OSHA, that they are no longer requiring businesses to have a COVID prevention program. So we are happy about that. But anyways, it's the same thing. These are programs that are EAP. These are safety programs that are required for businesses to have. And workplace violence prevention is one of them. And so that you should have already trained your employees on that. And that should already be an active program in your business because it came out in July of last year. So I would get with your HR, or if you have a safety manager, and have them kind of OSHA. I do want to make note that Cal OSHA does provide these prevention plan templates for free online. They're plug and play. So if you don't have a safety person, a lot of small businesses don't have an HR person. If you are not with BBSI, you can go on to Cal OSHA, and they do have forms where you can print these or download them and do a plug and play and kind of just put your name, your company's name and all your information in there, and then you have the programs. It is the bare minimum, and it's not like having a safety person or having a PEO do these things for you, but at least it covers you from the bare minimum, so you are in compliance with OSHA. Workplace violence is one of them. And so I believe that there's every 6 months you have to do something as well. And you have to kind of go over to make sure that, especially people dealing with retail, restaurant business, you guys kind of sometimes bar businesses, you guys deal with rowdy customers and things like that. So even if nothing physically happens to your employees, that is still considered workplace violence. So there's like a log you have to keep. And so I can provide more information for that. And I can provide the link to OSHA should you guys need that assistance for a workplace violence prevention program. But it is not covered in this legal update because that would have been included in last year's legal update.
Okay. And then lastly, is there a limit of time that can be taken off? So I'm assuming that's with a leave of absence or something like that.
Correct. It's kind of they kind of leave it up to the employer for a reasonable amount of time. I'm sure it's not 6 months or anything extensive like that. They can use sick time. It's kind of, I want to say the same like bereavement, 4 to 5 days is sufficient enough. Obviously, it's at the employer's discretion. Should you if the employee comes back to you and they got to go to court and they have to go out of state for it, there's accommodations that you can make. Since it's a protected class, I want to say accommodations is the route you should go, and you should always try to make accommodations. Obviously, if they're trying to leave for 6 months, that's probably going to be detrimental on small businesses, especially. But a few days to a week, I think, is sufficient enough. But every situation is different depending on, I can imagine, sexual assault, you probably might need some extra time off, or physical violence, you probably are going to need some extra time off and not just 2 days. So I think you use your discretion.
So what you're saying is it varies based on the situation
Absolutely.
and at the employer's discretion. And, and that's really important because, you really need to keep that open dialogue. And I know sometimes it's embarrassing for employees to share what's going on, but at the end of the day, in order for, to be understood and to be granted that time, sometimes you really need to just share.
Yes, absolutely. And like I said, keeping an open door policy where employees feel comfortable and they feel supported by you, it goes a long way. And those are the employees that are going to run through brick walls for your business. And so those are the employees you want to keep. Paid family leave, AB 2123. Employers are now prohibited from requiring employees to take up to 2 weeks of earned but unused vacation before receiving benefits under California Paid Family Leave Program. It used to be where we would require employees, you have to exhaust all your vacation. Now you can't do that. They can keep their vacation, and then they can apply for benefits. Granted, if they apply to the state, there's still a 7-day waiting period. So a lot of people will want to use their time off so that they aren't out 7 days, because SDI doesn't kick in for 7 days when you go out on a leave of absence. So they probably will still want to use it, but you can't require it now. And so the law is obviously going to result in a need to amend family leave policies employee handbook. So if your handbook does state that they have to exhaust all PTO or vacation, that will need to be amended and removed from your policy and your handbook. The wage replacement rate will increase to between 70 to 90%. I had a baby in 2021, and I think it was about 70%. So now it's between 70 and 90% of the wages the employee earned in the highest quarter of the base period, which they calculate. And it depends obviously on their wages earned. So the only major thing that changed to PFL is the fact that you can't require them to take 2 weeks off. And so just to make sure to update your handbook. Employment discrimination, SB 1100 for driver's license. So it makes it unlawful for an employer to include a statement in a job advertisement, posting, or application, or any other material that an applicant must have a driver's license unless both of the following are satisfied. The employer reasonably expects driving to be one of the job functions for the position, and the employer reasonably believes that satisfying the job function using an alternative form of transportation would not be comparable in travel time or cost to the employer. So taxis, carpooling, bicycling, walking. So I would say unless they're a delivery driver, you shouldn't be requiring them to have a driver's license, or unless they're going to be driving, like in my position, I have to go out and visit clients. I'm going to be driving. I'm going to need a driver's license. If they're driving a company vehicle, they're going to be delivering food, delivering items. They're going to be box drivers, whatever it is, those jobs, yes. But if they're going to be a receptionist and they're not going to drive, you cannot require that they have a driver's license. If they're going to work in the back and they're just a chef, they're not going to be driving. You cannot require a driver's license. So we just want to make sure that you guys amend or change any applications, job postings, anything like that require a driver's license for anyone unless they're going to be driving on behalf of the company. And I would say majority of clients, they're not going to be able to be in a bicycle or walking to be able to do these types of deliveries. So this is just to make sure that you guys amend that. And like I said, most employers, they know that they only really need a driver's license for employees that are going to be delivering. But if for some reason your business requires a driver's license to work for you and you're not a driving business, it is now unlawful for you to require it.
Wow. Okay. So someone is asking, what about caregivers that care for clients at the home of the client?
Regarding drivers, are we talking about driver's license?
Yes, drivers.
If their job requires them to drive, then they need a driver's license.
So for example, I'm a caregiver.
Okay, go ahead. Sorry.
Oh, sorry. Like a caregiver. I'm a caregiver for Susan down the street, but I need to pick up medication, run them to their appointments. So in that case, they would need.
Okay. Absolutely. Because their job is required to drive, and especially because you're going to be driving other people, absolutely you have to have a valid driver's license. Any position that requires driving, even if it's twice a week, they're going to be driving. You are required to, you never know, it could be an emergency. They need to go I want to go grocery shopping. You got to take them grocery shopping. You are required to drive them because they can't drive themselves. If your job requires you to transport or to drive, yes.
And that should be clearly stated when requesting to be hired, right? In the
Correct. It should be in their job description. Absolutely. In their job posting. And then obviously, if they're driving company vehicles, I recommend doing DMV pools. That's absolutely important as well.
Okay, and then someone is now asking, back to the medical leave. So should it be worded that it will be unpaid time, but they have the option of using vacation or sick time?
Correct. Yep. And then they apply through the state for their funds. If they want to, they would apply through the state, but it is an unpaid leave. All leaves are unpaid leave. FMLA is an unpaid leave. CFRA is an unpaid leave. ADA leaves are unpaid leaves. They're unpaid for the employer, but they can get paid through the state. So I think that's where people get confused. When we say unpaid, it's unpaid from the employer, but they can go through the state and get paid. They go through EDD, and instead of choosing UI, which is unemployment insurance, they go to SDI, which is short-term disability insurance. So when they go to EDD, there's two different options, and that's how they'll apply to the state. So when employees sometimes get confused when you put unpaid leave, well, it's because it's unpaid by the employer. So you guys don't need to pay employees. They can use their sick time if they choose, their vacation if they choose for that 7-day waiting period, but it is an unpaid leave, whether it's PFL, PDL, because pregnancy disability leave is also a leave of absence that's unpaid, but they can get paid through the state. PFRA, which is 5 or more employees, and FMLA.
The next question, what if they have a driver's license, but it's from out of state? Can you request a California's driver's license or it doesn't matter?
Well, actually, in California, and I know this because when I moved from Colorado, I got in trouble. You have 10 days, unless the laws change. I was told that if you relocate, you have 10 days to change your driver's license over to California. So if they have an out-of-state driver's license, they're employed here and they're working here, they need to have a California driver's license. Again, I'll double check the law because I'm not 100% on the state laws with driver's license, but I know that I was told by the police that I had 10 days from relocating that I needed to get a new driver's license. But I can look into that for you to see if that law has changed. But if they are living in California and they are employed in California, they have to have a California driver's license. There are instances where people drive semis, so they live in Arizona, but they travel a lot between California, Arizona, Colorado, and they're constantly in other states. That's different, but they live in Arizona, so to speak, right? That's different. But if they live in California and they're employed in California, they have to have a California driver's license. So I think it would depend on if they're long haul drivers, there could be out of state. So it kind of would depend on where they live as well.
Okay, and then just to add to that question, does it matter where the driver's license is from? Only because their insurance company prefers to insure a California driver's, which should be the case, right? I mean, you are doing business in the state of
Yep.
California, therefore you have
Absolutely.
a California insurance, therefore you should have a California driver's license.
Absolutely. Yeah. And again, your insurance, if that's what they dictate, then you have to abide by that because that's what I know some companies, their insurance only allows drivers that are 21 and over. They don't allow drivers that are 18, 19, 20 years old. So your insurance will dictate that for you. But I am going to look into the out-of-state laws regarding driver's license, and I'll put some information in the chat afterwards so that I can give you that information. But the last I heard, I was given 10 days after I relocated. So if they live here, they should have a California driver's license.
And they might want to check, on the DMV website.
Yes.
Just to make sure and then follow those guidelines.
Yes, absolutely. SB 988, Freelance Worker Protection Act. So following a similar Los Angeles law, SB 988 creates the Freelance Worker Protection Act, which imposes requirements on employers that form agreements with freelance workers for professional services. These are like 1099 for the employer that are worth 250 or more. So if the contract falls under the Freelance Worker Protection Act's scope, the law requires that the contract be in writing and include certain information, names, dates, list of services, and payment information. Additionally, the payment must be made on the date specified on the contract and no later than 30 days after completion of services. So it applies to independent contractors, those are 1099. Mm-hmm. Who are hired to provide professional services for 250 or more. Professional services include marketing, human resources, travel agencies, graphic designers, grant writers, fine artists, photographers, videographers, writers, editors, content creators, barbers, cosmetologists, and more. And if you look up Labor Code 2778, it will give you a more exhaustive list. The contract must be in writing and maintained for 4 years. The contract also must state the name and address of each party, itemized list of services to be provided, including the value of services and the rate and method of compensation, and then the date by which the freelancer must submit the services that are being rendered. And then obviously the payment needs to be made by the date specified or no later than 30 days after the completion of services.
Okay, and I like the must submit list of services rendered. And I know
Yes.
in past experience, I've had contractors who just submit an invoice with services rendered, I don't know, $500. And you're wondering, what did they do for $500? In the event you get audited, you know, to me, I'm always audit ready.
Yes.
Anything can happen. So I do both old paperwork, you know, keep my files, my paper files, and I also keep everything in the cloud just in case, you know.
Definitely. I agree 100%. Document it or it didn't happen. To elaborate on the freelance worker protection, must be paid by contract date. If the worker requests but is refused a written contract, the amount of compensation determined by rate, you can get a lawsuit for it. If the worker requests but is refused a written contract, that could be an additional $1,000. If you fail to pay on time, it could be twice the amount of unpaid compensation. And then any other violation, damages equal to the value of the contract or work performed, whichever is greater, plus obviously attorney fees, cost, it could get expensive. So we want to make sure that you're abiding by that. Like I had mentioned, Labor Code 2778 or SB 988. If you guys look up those, it should give you more details regarding the entire list of the different professional services that they are referring to here. Okay, social compliance audits, SB 3234. So I'm going to high level this. Again, the slides will be there for you. You can stay on, hopefully you do, as we go through this. SB 3234 requires public postings of information related to voluntary social compliance audit. A social compliance audit is a voluntary assessment of an employer's operations or practices to evaluate compliance with state and federal labor laws, including wage and hour, health and safety, and child labor law. This is the year's most notable new labor law, which is ultimately aimed at protecting minor employees. I don't know how many of you guys have businesses where you employ minors. Employers that opt to voluntarily undertake a social compliance audit will be required to post a link on their website to report detailing the audit's findings regarding the employer's compliance with child labor laws. According to the new law, a social compliance audit is a voluntary, non-governmental inspection or assessment of an employer's operations or practices to evaluate whether the operations or practices are in compliance with the state and federal labor laws, including but not limited to wage and hour, health and safety regulations, and obviously that includes child labor. Though the audit may cover a variety of issues, the specified report must include certain information related only to child labor law compliance. Employers that undertake this type of audit should review the new law and consult with legal counsel with any questions. When the audit was, you need to include things of when the audit was conducted, whether it was conducted during the day or night, whether the employer did or did not engage in the use of child labor. It sounds so bad when you say child labor, it sounds illegal, but whether a copy of any written policies regarding child labor, and whether children were exposed to any hazardous or unsafe conditions, and whether children working during school hours or during night hours. So if you guys do employ minors, that is an extremely important thing that you should look into as far as a social compliance audit. So here's kind of a high level of other legislation that was signed into law. AB 1815, the Crown Act amendments, eliminates the word historically from protective hairstyles and race, and it adds protections under the Civil Rights Act. 1976 requires Cal OSHA to propose a rule requiring first aid kits to include Narcan. Obviously, unfortunately, the United States is battling a horrible drug epidemic. So Narcan is now, again, 1966, it's requiring Narcan at stadiums, concert venues, amusement parks. And 2975 requires OSHA to amend the hospital workplace violence prevention standard to include metal detectors and security guards at hospitals. SB 1137 amends FEHA to protect discrimination on the basis not just of an individual protected traits, but also on the basis of a combination of two or more protected traits, which will require an update to EEO and to the anti-harassment policy. So once that change comes into play and we get words on that, we'll be making sure that our employers are trained. And then 1870, employers will need to include information on poster concerning an injured employee's ability to consult a licensed attorney to advise them of their rights under workers' compensation laws. I have done workers' compensation law, workers' comp for a lot of years, and this law is about posting. All of the new California posters should have it on there, and it's basically just letting them know, as if they already didn't know, from a business standpoint, that they can consult a licensed attorney to advise them of their rights and workers' compensation laws. We all know California is extremely litigious. Most employees are already aware that they can consult an attorney, but now you need to post it in your place of business. And like I said, when I send out the website for the CRD, it will be on there, but also it should be on all labor posters for 2025 already. So vetoed installed bills, the increase the statute of limitation for group FEHA claims with CRD to 7 years. It was vetoed. Workers' compensation presumption for heat illness and farm workers, that was vetoed. The prohibition of using criminal history and making employment decisions, that's been stalled, which is very interesting. And the right to disconnect, this bill grants employees the right to ignore workers' communications outside of work hours, except in emergencies or for schedule changes within 24 hours. That was mentioned in the beginning of this presentation. That has been stalled. 2751 right now is stalled. It doesn't mean it's been vetoed, so it could be coming down the pipeline either later this year or next year. So we will keep an eye out for that. 3058, universal basic income for AI job loss. This bill was to create California unconditional benefit income pilot program to provide monthly assistance to individuals who were employed due to automation or AI after exhausting their unemployment benefits. This has been stalled. So that's very interesting. It wasn't vetoed, it was stalled. Massive unemployment tax increase. The bill was to bill raises the wage base and maximum weekly unemployment benefits by up to 55%, which also adjusts the tax percentages for employers to be taxed and provides new eligibility for unemployment insurance. That's been stalled. So we would definitely want to keep an eye out for that. The role of AI and employment and notifications to employees and applicant if AI is involved in decision-making, that's been stalled. Any more questions?
Can you share why businesses use BBSI?
Absolutely. And I'm speaking from a four-wall. I'm probably one of the newest people here at BBSI. I've been here for 2 years. I didn't even know what a PEO was. I didn't know what they did. And coming into BBSI, we provide advice from a workers' comp standpoint. And we actually, from an HR standpoint, we advise our clients whether new laws are coming out. We assist with handbooks, policies and procedures, coaching, training management teams and owners on disciplinary action, safety standards. Everybody has their own risk assessment person. We do workers' comp. We also have workers' comp admins here, and we are the liaison for the employer and the workers' comp insurance agency. We provide that as a service as well. We also provide dental, medical, auxiliary benefits. We also have an LMS system for a learning management system. And we do 401k. I mean, we kind of are a one-stop shop all the way around. I would also add that there is a lot of competition out there, and I know that there's a ton of PEO that you guys can choose from, and I'm not tooting my own horn because I work for BBSI, but I came from working with ADP, and calling a 1-800 number and getting a different person every single time is extremely daunting when oh my God, I have to call you back. And then I call back and I get somebody else and I have to re-explain what my problem is and re-explain things, where in BBSI, my 86 clients, they have my cell phone number. They call me, they text me. If they have a question, they know they can get in touch with me. All of our clients has a dedicated team. Our dedicated team is a BP, and that person is there to help you from a strategic business standpoint, where they help you guys with how to set your business up correctly, how to make sure that you guys are set up for success from a financial standpoint. Then you guys have a person like me for HR. I'm there to make sure that you are compliant from an HR standpoint, from the point of onboarding through the entire scope of your time with us. We help you with everything. Like I said, helping with policies, handbooks, keeping you compliant. Then you have a dedicated risk manager. He comes out quarterly to your space. He assesses your business. He makes sure that you guys are not having any major OSHA violations. He provides all of, or helps you guys provide all of your required programs that you were supposed to have for your business. He does, he's even helps, or he, like, I'm talking about mine, but they all do. Should you guys have OSHA come into your business and you're freaking out and you don't know how to handle it, he will go and he'll help you go through each violation and make sure that you're compliant. And then when you guys have a dedicated payroll person, they process your payroll. They help you with 401k, with notices that you get. Your entire team is there for you 20, I want to say 24/7 because that's the way I am. But my clients, like I said, you guys can call me personally. You guys can call your people personally. You guys don't have to get a 1-800 number. It is a very, we want to provide a very personal experience for your business. That's your baby. We want to help you take care of your baby. And that's where I feel we have a difference from a lot of the PEOs out there, is because we give a very personal experience for you. You get us, and exactly who you see is, that's a person you're going to get every single time you call. So I think that kind of helps separate us from other PEOs and what we provide.
And I can actually vouch for the services that you do, because we use BBSI, and I tell you, it makes payroll so easy. You enter, it calculates, you finalize, and bam, right? And so for a small office like ours, it's really behooves us to have a partner like you who can help us make sure that everything's done in a timely fashion. I know I just requested our employee handbooks for 2025, and I'll get those in a timely manner. Just, I know I need to provide updated information so that you guys can populate it. But I'd like to hear from Carolina. Carolina, welcome.
Good
I know I'm
morning,
putting you on the
everyone.
spot, and I apologize.
No, I'm in love with the opportunity. Thank you very much, and I appreciate everyone who came on board. But BBSI is truly a high level, high touch boutique service. So what makes us different is our consultants are the best in the business. No one can touch us when it comes to servicing our clients. If you hate workers' comp audits, we can take care of that for you, as we do payroll, and therefore you don't have to worry about the audit again, ever. As far as how we manage our clients' relationships, we advocate for our clients. First and foremost, we want to earn the trust of the clients. No one is going to come and ask the difficult question if you don't trust our consultant. So I'll make the example. Would you ever go to someone that will do your taxes for free? And the answer is probably no, because you don't know them. And so where we really score high is how to mitigate exposure for our clients, starting from, we have a 24/7 nurse hotline. If you have a workers' comp with us, your employee can call that hotline immediately, and we'll start working on that claim from that moment on. We start protecting your interest from that moment on. Our litigation, now that you have to have the notifications on the board that says, employee, you can call an attorney, these are your rights. When we start having that employee touch that nurse immediately, we mitigate the litigation by 50% on that alone. When it comes to HR consulting, we addressed your question immediately. What I loved about this interaction is that someone had that follow-up question. Imagine being able to do that with someone on the phone instead of having to type that, right? We can address the life cycle of your business for that specific employee that's making you lose your hair, and you can come back and say, remember that we spoke about Carolina? She brought a cow to the office now, and we're not allowed. What do I do about that, right? So when it comes to the service, we are very much boutique, and we are available all the time. We have a lot of companies that do wonderful things. The other piece is, if you are looking for maybe health insurance, if you are more than 100 employees, you can buy wholesale health insurance. With us, you can buy it under our umbrella and have the same access to that type of health insurance rates. And so in essence, you have the economies of scale of coming to us all under one roof. And you can have some things and not all of it. You don't have to have it all. Our only mechanism is to do payroll. And I'm going to stop because I am long-winded and I appreciate Olivia giving me the spot.
On that note, I want to thank you ladies, Carolina and Candace, for your time. I want to thank you on behalf of everyone here at the LA Latino Chamber for sharing your morning with us. Any questions, you can send them to me at olivia@lalcc.org. So thank you for joining us and God bless.